to introduce the next speaker, Honorable Miss Justice Ritu Tagore, Judge, Punjab and Haryana High Court, who started her illustrious career as a judge in the state of Haryana on 20th February 1992. Honorable Ladyship was promoted as a judge of Punjab and Haryana High Court on 2nd November 2022. May I now request Honorable Miss Justice Ritu Tagore, Judge, Honorable Punjab and Haryana High Court, to apprise us on the topic of counseling, conciliation, and mediation in resolving family disputes, relevance and importance.
Hello. Good afternoon,
Yes,
all.
Ladyship, you're audible, yes.
Good afternoon, all. Are you? I'm audible to all of you? Yes, Mahavi. Am I?
Yes, ma'am.
Yes, ma'am.
Okay.
Yes, ma'am.
So today is Makar Sankranti, and I wish you all happy Makar Sankranti to all of you.
Thank you, ma'am. Thank you so
Thank
much.
you, ma'am. Thank you, ma'am.
Actually, it has to be a
Thank you, ma'am.
more a interactive session than a reading one. But I think so before we go for this session, we should, understand what is mediation, reconciliation. You all know about it, but let's recapitulate again and, understand what does it mean, in fact. So I start I'm reading some of the, lines and my own preparation made. So that we can understand better what is mediation, reconciliation. Okay. So there is a quote by Abraham Lincoln: discourage litigation, persuade your neighbors to compromise whenever you can. Point out to them how the normal winner is often a loser in fees, expense, cost, and time. So ADR, mediation and conciliation, is just a form of ADR method. As we all know, since time memorial, if you ever watched in villages, elder people, they used to sit together and persuade the parties to come to some realistic understanding and solve their disputes. This panchayats and sarpanches, panches, and other elder member of the family or the village, they used to sit together and try to solve the dispute between the parties. Or if we go back to mythological era, so you all know Lord Krishna, how he tried to mediate contended brothers to settle the matter between them. So according to me, it's a viable tool for a settlement of disputes. It provides a prompt remedy with high hopes of saving the relations amicably, and which is earnestly required in family disputes, just such as custody matters, all then your maintenance, then marriage cases where parties, fell together apart. Then, so if I say this is a method where there is no interference of the court or a judicial body. We try to make parties to sit together and have their own, own views put forth, so they can settle, their rival contentions or their matters. So as a referral court, what we see, we send the matters for a probable settlement. So mediation is essentially a negotiation and not a adjudicatory process where mediator facilitates the process in which parties participate directly in the resolution of their dispute, decide the terms of settlement in a mutually uh, agreeable manner, irrespective of their rights and liabilities. So proceedings in mediation are held in private and it is a voluntary process. So what does a mediator do? You all know and you have been referring, but let's revise again. And so mediator is a impartial and neutral person. He interacts between the parties, try to facilitate communication between two warring parties, or where essentially when dispute happens, first casualty is you stop communication. This is the first kind. So mediator helps them to communicate between them, identify the barriers of their agreement, their interest. They identified the interest where there is a conflict. When to how the conflict arises when there is a conflict between the two interests. So they also try to develop the terms of the agreement. And mediator does not impose a solution but create a conducive environment in which disputing parties can resolve their disputes. So it is an informal process. There is no strict binding rules or procedure. It's completely confidential process and enables the party to interact one to one. They make them sit. Sometimes they have a private first meetings with them, then with one party, then with the other. Then they make them to sit together. They may invite their, friends or relatives, which they feel that they can help uh, to solve the dispute. So conciliation, it's also the same, it's overlapping one way. It's but still it is a third in which a third neutral party called a conciliator who facilitates mediation by playing active role. So it is a party centric, in fact, negotiation where consenting parties are mandatory and confidentiality is the key. So now if we come to, in a nutshell, say what are the benefits of mediation? This is quick, responsive, economical, no extra cost, harmonious settlement, creating solutions and remedies, confidential, informal, parties controlling the proceedings. So, which is, I think, a very beneficial thing here. The parties then they get satisfaction. They feel satisfied, like we are being listened to, and we have a role to say something, and we can, some resolution, then some settlement or agreement comes out of it from their participation. So if we have a mediation versus litigation, so then again there is no loss of time in mediation. Financial investment is no, there is no financial investment, preserves ongoing business and personal relationship, follows flexibilities, allows flexibilities, control and participation of the disputing parties. So it is satisfactory thing. So this is precisely what I, have conceived what mediation is and what are its benefits. So before we, have a talk with you all and share your experiences with each other. So let's have a very short, uh, flipping over the overview, we can say, of different provisions. Now, if we come to Hindu Marriage Act, then you see Section 23. So it provides promoting conciliation, and it says the court shall, at first instance, in every case where it is possible, consistent with the nature and circumstances of the case, make every effort to bring parties together and try to solve disputes in amicable manner, and promote and preserve the sacred union of the parties to the marriage. I think Section 13B is also one way, endorses and promote mediation. And we can say it is a result, that's a petition coming for under 13B is a result of mediation, which helps the party to, to solve, in fact, have solved their dispute, and they have come to the terms, and they thought of, separate, dissolving their marriage. So it is in fact a byproduct, is a result of mediation. So even I find Section 22, which speaks about prohibiting publishing and printing the matters relating to family matters, is also one way encourages conciliation between the parties. Because see, when I know my things are not going to be out or something, or I have to say something, when we are conciliating or we are mediating, you are also doing it sometime in a open court. So they say so many things which they do, in fact they don't want to say, and they also say ki, like we want to say something, we take us in chamber, they they open up more, they say so many things. So this Section 22, in fact, I think encourages them, they one way, like to have a camera proceedings, and they can come out with their problems, they can come out with their solutions. So it also helps one way. Now, if we come to Special Marriage Act, this act also speaks about reconciliation, Section 34. These provisions are similar to Section 23 HMA. It also encourages reconciliation, and even allows you to, postpone the matter for some other day, and give them the chance to have a think over it, and come out with the solutions which we really want in mediation. Similarly, if we come to a Foreign Marriage Act, Section 18 provides that provisions of Chapter 4, 5, 6, 7 of Special Marriage Act shall apply. So if you come see Chapter 7 of Special Marriage Act, it also speaks about same thing, reconciliation. And then we come to Divorce Act. This also gives the opportunity of settlement between the parties. Section 10A, which is equal, like Section 13B, speaks out about divorce by mutual consent. Then you come to Section 40 of this act, which talks about the inquiry to be made by the court before passing a decree of dissolution of marriage, so as to existence of nuptial or post-nuptial settlement made by between the parties. This, I think, is more progressive, speaking about the pre-marriage, agreements, if they have to make. So in order to have, less disputes or comfortable living, one way, which is not there in our HMA or other provisions. Then even in mediation is there in DV Act. So if you come to Section 14, so it also says magistrate who's adjudicating the dispute may at any stage of the proceedings direct any or all of the parties to undergo counseling. Such counseling may be with any member of a service provider who possesses the prescribed qualification and experience. So you have noticed, day one, every day we, quash so many criminal cases, uh, only and under 498 or DV or related family matters when they, settle their disputes. And what to say about the Family Courts Act 1984? So this is, if you go through the preamble of this Family Court Act, you all have gone through it, but see how it starts. States that one of its objectives is to promote conciliation and secure speedy settlement of disputes relating to marriage, family affairs, and matters connected there. Now we come to section 5 also of the Act. It also provides institution and persons working in the field of family, social welfare, and agency speaks about and associate them with family courts. So in addition, there too, then we have section 6, which also provides for appointment of counselors, I think, which is not so far. We are having this facility, and which is the necessity of every family court. I think so. In a passage of time, we are going to have these counselors. So this will certainly aid you in resolving the dispute in family matters. Then we come to section 9. I think this is the most important section. In fact, the main star provision in the section in this act. So it's what it says is duty of family court to make efforts for settlement. It says in every suit or proceedings, endeavor shall be made by family court in the first instance where it is possible to do so, consistent with nature and circumstances of the case, to assist and persuade the parties in arriving at a settlement in respect of the subject matter of the suit or proceedings. And for this purpose, a family court may, subject to any such rule made by High Court, follow such procedure as it may deem fit. So it casts a duty upon a family court to assist and persuade, which probably when we are sitting in a family court, having lots of cases on the board. So we think how to deal with all of them. And probably in that thing in our mind, sometimes we don't give that much of time to a particular case where at least you should make a point. Today I'll try to do this at least in those cases where there are hardly any possibility to have a settlement. It's really satisfying. If you really do this, it's really satisfying. I know it's emotionally very challenging. Even I, when I used to sit in a family court 4 to 5 months prior or so, even I used to get sometime have those irritational, but again, so we have to. It's a really mind-boggling, but emotionally challenging also. But we need to. I think so. It makes us a better person one day or the other. I used to, sometimes feel, with my daughter, क्या करते हो छोड़ो क्या नहीं करती. So after it, मुझे थोड़ा सा I've controlled my anger and my emotions after dealing with this looking, see, it's a fight of emotions, before us. So variety of emotions, variety of, people, they have their different mindset. So they come before you. So you have to be a sadhu to some, कई बार साधु करके बैठना पड़ता है. Sometimes you have to sit, and behave like a elder sister, mother, grandmother, sometime as a preacher. So this has to. कई बार आपको थोड़ा, गुस्से में भी बोलना पड़ता है. Sometimes all तरीके, गुस्सा, प्यार, carrot and stick policy, you have to adopt that. So the duty is to persuade. This is a family dispute of your own brothers, sisters, apni family mein. Let's say we have today, every day we behave like a family court judge in our respective families, no? बच्चे आपस में लड़ रहे हैं. So one kid is coming to you, asking you, he or she has snatched, pencils from me. He has destroyed my book. So you have been doing all this thing. Sometimes you're, telling them, no, bache, he or she is your younger sister. You should not have done it. You make them realize, okay, you prepare another, whatever the chapter or the thing he has spoiled, help your sister to, build it again. So this way, so this section 9, we revert to the same section. Subclause 2 say if in any suit or proceedings at any stage it appears to family court that there is a reasonable possibility of a settlement between the parties, the family court may adjourn the proceedings for such period as is think fit to enable attempts to be made to effect such a settlement. The power conferred by subsection 2 shall be in addition to and not in derogation of any other power of family court to adjourn the proceedings. So this section not only says you to go for persuade the parties for settlement at the initial stage, but it also says at any stage. See, sometimes parties, they feel like, no, it is enough. We should now settle the dispute or resolve it one way or the other. And even you find it is there. So keep on hammering them, asking them. So one day you may, have a success of it. Now we come to section 10. It also gives family court the wider latitude of adopting its own procedure at arriving at settlement. So see, the law has given you such a wide power, so you can adopt your own procedure also. You are not to follow CPC. And then tell them if it is for the settlement. And section 11, again, this speaks about the camera proceedings. So this is also one of the, way like how we can have a settlement. It helps you because parties in a family dispute, in matrimonial dispute, so many things are there. So the parties don't feel, at ease in open court. I understand when we are having a family court, not all the times you can tell them to, have a camera. I understand all the times not a camera proceedings are there, but still try to, in some cases, or take them into your chambers. So here, actually, what I want to convey is when there is a camera proceedings, parties, they open up more. They open up more. So this help you to have a settlement. Then we come to section 12, which enables the family court to secure the services of medical experts, a person's professionally trained in welfare affairs, even section 13 also, though right to legal representation as such is not as a matter of right, it is so granted, but you can take the services of the advocates as a uh, amicus curiae. So what does it mean? As a friend, you tell them, be a friend for the both the parties. So sometime, you start behaving as a advocate, adjudicatory process, adversarial way. Tell them you are amicus curiae. You are a friend of the court. So what they happen, he'll say, she advocate say, they start, speaking for the parties. इसने ऐसे किया था, ये ऐसे कर रही थी, वो ऐसे कर रहा था. Then other side says, no, yeah, no, this is गलत, वो भी ऐसे कर रहे थे. So leave this. Tell them leave this. You are friend. Tell them to, behave like a friend and assist them in arriving at and see, you have given them the permission to. She says, tell them, yeah, you have given the permission to assist them. If you don't behave in that manner, you don't behave as an amicus curiae, you withdraw the permission. Tell them. So you all must be knowing the authorities, even number of authorities it is being said, like the family court should try to, help the parties to settle the dispute by way of mediation or reconciliation. So it's obligatory on the part of the family court to endeavor, make an endeavor to effect reconciliation or settlement between the parties. Now, if we come to civil procedure, CPC, it also section 89, then read with the order 10, how it also speaks about reconciliation, conciliation, then order 32A, this relates to suits relating to matter concerning family courts, family matters. So it also speaks about settlement between the parties. So if I say as a family court judge, you need to see also and tell the advocates, you have to advise them also. This is what I was telling you earlier also, to guide them, the advocates, because you see, presence of advocates, I think, is also very necessary, because they, help the parties and guide them in the process of mediation. They tell them how the mediation would take place, and we send them to the mediation centers. So they tell, and they also, help as a support system to the respective parties. Sometimes, so when they arrive at some settlement, they help them how to, draft their respective agreement papers. So you have to, sensitize advocates also in that matter and tell them, this is also your onerous duty to help the parties in such matters to arrive at a settlement. So if we finally say, what are the advantages of this? This is amicable settlement, speedier justice. This is easy to, parties have their choice to settle the disputes. So my final call, even your call is also, I should be the same. Go for mediation. This help the parties to have their dispute settled, and it is in the best interest of the parties, where children are involved, husband, wife, families are also involved. And one thing I see ki this saves, reduce the acrimony, the bitterness between the parties. which, arises from litigation. But in mediation, they part ways as a friend. This is the most important thing and beautiful thing which I find it happens in mediation. So this is the core satisfying aspect which I have experienced when I was as a family court judge. So this is a nutshell which I can say for mediation, reconciliation. These are the benefits. So I have gone एक छोटे से वो I was going through some lines वो मैं उठा लाई हूँ. So I want to say something. एक वहां पे ये लिखा हुआ था, एक छोटा सा समझौता एक बड़े मुकदमे से कहीं बेहतर विचार है. एक ये भी था, एक छोटी सी लड़ाई से हम अपना प्यार खत्म कर लेते हैं, इससे तो अच्छा है कि हम प्यार से लड़ाई को खत्म करें. सो कई बार क्या होता था, व्हेन आई यूज्ड टू सिट इन अ फैमिली कोर्ट, ना very good song used to hum. I used to hum and say something to them. Then sometime one if you go some news anywhere or I have read them, so I used to tell them, see, I have read this news and it's so wonderful. There was one I had read somewhere, if husband wife they fell apart, they had then they went through this divorce proceedings, then that both of them they got remarried and settled in their lives. Then that boy that his wife, probably then second wife, she died, and that man, he suffered a kidney problem and finally kidney failure. So that lady, probably the first wife, was in touch with that first husband. Then she came to know like he's having this kidney failure, and see, that lady gave a kidney to him, and see, he was saved. So these are the, I think, outcome of that mediation process where they fell apart though, but they remained friends. What I could conclude from it, they remain a very good human being or friends, with each other too. And they finally, this is how this happens. So it's all from my side. Now we interact with each other. So just experience your own, tell your own stories so we can, learn from it. Hanji, Virender Malik ji.
So good afternoon, ma'am.
Very good afternoon. How
Ma'am,
are
it was
you?
a case. I am fine. How are you, ma'am?
Ji, fine.
I'm dealing with a case of custody of a minor child. The custody has been sought by the grandparents on the ground that the widow have already sliced the marriage and residing in Rajasthan, and therefore the custody be given to us. So in that case, I have dismissed that petition and ordered that the child should be kept in the custody of widow lady who has sliced the marriage.
You should have given visitation rights also to the
Yeah,
grandparents.
I have given visitation right twice in a month and during summer vacation of the schools for 15
That's
days.
good. That's good. That's very nice. That we should not snap ties, no? Whatever happens, we should leave that thing up away. That should not be in hamper us from, there's no fault of the child. He wants company of his mother also. The father is there, he needs his company of his father, grandparents, extended family for his holistic growth. It's a good thing. But unfortunately, see, there's a lot of parental alienation of parent who's having a custodial right. They don't want to part with the custody of the child for a day or two also. So that's it. Even this our act also, that's also not with one way. You have to give custody one way or the other. It should be in a joint shared parenting. But hardly any of the parent who's having the child, they will not part with the child for even a whole one day or even one night. That's not a good thing. So we should try to break them, hamper them, keep on knocking them their head, make them realize, no, this is not good for the child. So later on, it really, it affects your psychology, way you perceive it. If you have a half side of it, obviously your thought process would be same, no? You won't be thinking in a broader manner, in a holistic manner. So it has to be. It's nice.
Thank you.
Anyone then? Alka Malik, I can see from Madam Alka.
Good afternoon, ma'am.
Hello, how are you?
Very fine, ma'am. Thank you so much.
हाँ जी,
Mm,
आप सुनाएं
ma'am,
कोई
we are
कहानी.
doing- कहानियां तो बहुत हैं, मैम. Especially when you are discussing about the child custody, sometimes the children, they feel so traumatized कि एक पेरेंट के पास रह रहे हैं, वो दूसरे पेरेंट के पास वो जाना ही नहीं चाहते, even बात भी नहीं करना चाहते. I can share one experience as per the High Court order when I was posted as additional session judge at Gurugram. One child was to meet his father, and it was ordered that he shall meet at my residence. So there I could see the trauma which the child was facing. He was not even willing to see his father's face, because since his childhood he was with his mother. He was, I think, 11-year-old, and he was staying with mother for last 9 years. So वो अपने पापा को देखना भी नहीं चाहता था.
See,
And
I
but
feel
एक
here,
घंटे तक अपने father जी.
I feel, here parents, whosoever who is not having the custody of the child, I don't know for what reason he or she, they don't knock the doors of the court immediately when there is a separation. Then obviously the other custodial guardian of, see, when you have fell apart, there is something or the other, and
Yes.
so that parent would always say something against the non-custodial parent. Now all sort of, because when the tempers are high, only then they have fell apart and there is no solution or communication between them. Then I think we sometimes we have a lot of cases. I think family courts are now burdened with so many cases, and every day many cases are being filed in the courts. In that also, please be sensitive when custody matters come na, immediately look into it and grant visitation rights initially, immediately. जितना
Yes.
जल्दी करेंगे उतना अच्छा होगा, I would say. If you won't,
जी.
the delay would cause havoc, because
Yeah.
the child will be away from the other parent, obviously. Then it will become difficult even for us also, when we want to
Yes.
we pass
That
an
was very
order.
natural. response.
When we pass an order, then orders are not being implemented, and parent would say, no, bacha nahi, he doesn't want, he or she, they don't want. So you see, you got to be very quick. So when these matters they come up.
But ma'am,
And
sometimes they are coming up after so many years.
Yeah.
That's the
That's the
rather
problem.
trauma for the child.
So
Ji.
immediately have the services. We are not like we are. You start have a counselors, maybe attached with the courts. So immediately have the services of any other counselor or child counselor, whosoever is available at the particular district or station. Counsel them, and the gap between the visitation right at that time should be more. I am of the view it should be more. So
Yes.
if we give them, okay, come after, have a visitation right once in a month, that doesn't serve the purpose. Purpose is to reconcile, to have the child should enjoy both the parents. He should know the other, parent of his or her.
Yes, this is for his, as you rightly pointed out, this is for his expansion.
Yeah, bilkul. Abhilasha.
Thank you so much.
Okay, thank you. Abhilasha. I see Abhilasha. Bhavna Jain.
नमस्कार मैम।
Namaskar ji, how are you?
मैं ठीक हूँ मैम। मैम मेरे पास तो ऐसा कोई पर्टिकुलर एक्सपीरियंस अभी नहीं है, लेकिन मैं अपनी जो मिलाती हूँ, जैसे कई कई साल की सेपरेशन है पेरेंट्स की और बच्चा एक पेरेंट के पास है, तो मैं उनको कोर्ट में ही मिलवाती हूँ, कोर्ट में बुलाती हूँ बच्चों को और कोर्ट में ही मिलवाती हूँ, क्योंकि बाहर अगर मिलाने की करते हैं, एक तो वो झगड़ा करते हैं, एक डीडीआर एंटर करा देते हैं, मॉल वगैरह में अगर कहीं भेजते हैं तो, और फिर एक और उनकी लिटिगेशन स्टार्ट हो जाती है पेरेंट्स की। तो मैं कोर्ट में बुलाती हूँ, घंटा, आधा घंटा, 2 घंटे, जितना भी बैठना है, और ज्यादातर लॉयर्स ही कह देते हैं कि जी हम चैम्बर में बिठाते हैं, तो उससे थोड़ी सी फर्क पड़ता है। लेकिन कई बच्चे बिल्कुल भी नहीं मिलते मैम, जो 15-15 साल से, 14-14 साल से बच्चों ने देखा नहीं दूसरे पेरेंट को, वो बिल्कुल बात ही नहीं करते। सामने कोर्ट में बैठे हैं, मैं इंटरेक्ट कर रही हूँ उनसे, मेरी बातों का जवाब देते हैं, लेकिन अपने दूसरे पेरेंट से बात ही नहीं करते।
कई बार ऐसे होता है
लेकिन
ना,
कर
बोलते
रहे
हैं
हैं।
बिल्ली के गले में घंटी बांधना। एक्चुअली ऑपोजिट काउंसिल को ही बोलो, you are to make the this meeting happen, उनको ही
ठीक है
बोलना
मैम।
चाहिए। So
हाँ
sometimes क्या है
जी,
ना, the
ठीक।
child वो काउंसिल नहीं जी ऐसे है वैसे, तो you said I want to see you are doing this thing, this has to happen, अपने वो बिठाइए and कीजिए। And in such
हाँ
cases,
जी मैम।
like custody cases, I'm always of the view, give them maximum access to the non-custodial your parent.
पेरेंट्स, हाँ जी मैम।
That may help, बच्चे they become a bridge sometime in the
लेकिन कई बार मैम
settlement.
लिटिगेशन सिर्फ ड्रैग करने के लिए भी करते हैं, जिस पेरेंट के पास नहीं है कस्टडी, वो दूसरी पार्टी को हैरास करने के लिए, क्योंकि हम कोर्ट में बुलाते हैं, बच्चा आ जाता है, जिस पेरेंट के पास है वो लेकर आता है, और जिस पेरेंट के इंस्टांस पे, पिटिशनर के इंस्टांस पे बुलाया होता है, वही गायब होता है। एक बार,
This
2
you
बार,
have,
3
you
बार,
know it,
हर
you
बार
know,
बहाना मार देते हैं।
you know what is happening before you. You can understand well ki why this case has been filed or something or the other. What are the bona fides of the party, why they have filed this thing. This you have to gauge and assess and then do it. But as and when there is a child,
हाँ
try
जी,
to
जी,
uh,
हाँ जी,
give
हाँ
them
जी
the
मैम।
custody. कई बार क्या होता था, I used to, then I started it when she's the husband or the wife, whatever, whosoever, we want to meet the child, particularly in where the father is not having the custody of the child. So I used to say then, okay, give this much of traveling charges and the cost. So, and come, and I want to meet the child every day. Okay, make it, then come. Give this much of traveling expenses and
जी,
You just see whether he'll if he really, have the bona fides, he'll pay the money. Otherwise, he'll say one this or the other. These are the things you have to evolve, tricks. But the basic purpose should be, we should make the, warring or litigating parties together. Our purpose should be this. This should be.
ma'am.
Yes, Kumkum,
Thank you, ma'am.
Kumud, where are you? I can see you. Kumud? No. Any other, please? Hanji Kumud ji. I can't hear you. He's traveling probably. Amit Singla. Gagandeep, madam. I can't hear you.
Good afternoon, ma'am. Am I audible now?
Yes, ma'am. You are audible.
Ma'am, I had a case just before the vacations now. So it was 11th month old child. It was a custody matter. The mother came to me. She said ki my child is seriously sick and the father is not taking care of him. So because it was a minor child of 11 months, I permitted her to have custody within 7 days. After 7 days, the father came to me and said that she will not take care of the child as she goes out for the parlor services and she will not take care of. The mother used to reside in Delhi. मैंने उससे कहा, father से I asked, will you like to have a room in rent in the same vicinity where the mother resides and take care of the child during the vacations only till the time I take up the file again. So after convincing for several times, he agreed and went there. He lived on rent for 7 days. He came back to me and they both of them reached at the settlement and started living together.
So what a wonderful, very nice.
Yeah.
It gives you satisfaction. Yes, you've done
Yes,
something,
ma'am.
at least for the
Yes.
family, for the child. It's a wonderful to see how the things. It's
Yes.
nice, very nice. Hanji Ritu,
Thank you.
ma'am. My namesake, Ritu Behel ji.
Good afternoon, ma'am.
Good afternoon. How are you? तुम्हारे पास तो
Very fine, thank you.
अंबार है experiences का, नहीं?
A little. I think this is my second stint as a family court judge, so probably I have a little more experience than usual.
First, you tell all of them how you are maintaining yourself in a family court. नहीं तो generally all they say कि it's a very emotionally draining. We don't want to be in this court. So
I don't know, ma'am. I think
what is your say on it?
temperamentally I'm attuned. Yes, it is very draining because initially when I started with the family court in Gurgaon in 2014, it did exhaust me, it did tire me out, and it did weigh on my mind. But then I'm also into meditation, so that helps immensely, ma'am. And gradually over the years, I've learned to keep my work away from my personal life, and I do not let it impact my life overall. So I think work should be left in the court so that we come to the court each day with a very fresh mind. If we carry baggage home, it doesn't really help. A judge needs to be very balanced in his approach.
Yeah, yes,
So
yes.
I think that is it.
So
that is it.
any incident which really, still.
Yes, ma'am. We're talking about custody of children. The matter is still pending before me. This is a highly acrimonious litigation between the couple. They have a child who's about 8 years of age now, today.
Okay.
The litigation was perhaps started when the child was 5. and they have a number of litigation going on. The husband is from the paramilitary forces, so the child primarily stays with his family. The wife lives in a village which is pretty distant. It's about 50 kilometers from the husband's village. Now, when she came to me last year, she alleged that the child was being drugged. And the husband would say that the child has a hole in his heart for which he needs treatment. And whatever effect the medication may have, apart from that, nothing is being administered to the child. I have, each time the child came to my court, and I used to ensure that the child comes to the court on every date of hearing, I have observed that the child was very lethargic and he would never be able to meet the mother in that 2 hours of visitation that had been granted to her. So one day there was a really nasty scene between the couple, and the wife started crying. She told me, "Ki madam, mujhe ye bacha de do, and I will prove to you that he's drugged." बच्चे की मैम दिवाली की छुट्टियों में I gave her the child for 15 days. When the child came again, ma'am, he was a new boy. He was chirpy, he was bubbly, he was skipping around like a normal 7-8-year-old. He came and recited poems to me. He demanded that I give him some sweets if I wanted to hear more poems. He was that confident. A child whom I had never seen actively even sitting up straight. So when I asked the husband, he said, Kiji, I don't know what medicines the doctor gives. The mother told me, Ki, here is a list of tests that I've got done. And he doesn't have a hole in his heart. He doesn't have any other kind of issues. And I have also got him mentally examined. So the father put in an application that the mother had treated the child with extreme cruelty by getting him unnecessarily medically examined from various quarters. I have dismissed that application because there is no such thing. Rather, she has brought to the fore that the child is absolutely right. But she could not, the medical examination that was conducted could not detect what had been administered to the child. The child was handed over to the mother after about a week. I think some cleansing process may have been done during that period. Now, ma'am, the village panchayat and the family is sitting together trying to settle the dispute. It hasn't yet been finally done, but they're on their way.
That father needs to be counseled more than the.
That is another thing, ma'am. I believe Chandigarh has very good set of counselors, but in our smaller towns, we lack them. And I think the courts are very challenged because of that.
Yeah, I understand. In the last family court workshop, even I had put up this thing like we should
Yes,
have a
ma'am.
counselors attached for each court. I think it will be done in
Gradually.
gradually.
One
So,
thing,
no,
ma'am,
we need to be now counselor. We need to be everything. We should do it. This is challenging for us, but we are well equipped with all these things, right?
yes, ma'am, definitely.
All these cases had made us so strong.
Yes, ma'am, definitely.
So, any more or any sort of clarification or something? Anything more? Or you all want now have your food, huh?
Good afternoon, ma'am.
Hanji, how are you?
I'm fine, ma'am. Ma'am, just one suggestion. Like, we don't have counselors, it's a major issue, but I think all officers who are in family courts, they should be provided this mediator training that will increase our efficiency in mediation and the counseling process.
Yeah. This I also agree. I remember when I was a district and session judge, just hold. District and Session Judge Panchkula. So I requested Punish Jindia at that time. He was, at Halsa. So I said, I want to be go through this. I want to go through this training. So fortunately or unfortunately, I had occasion. It was for 2 days, but I could attend for 1 day. So the resource person, that was the second day. resource person, they gave us the problem, and this is the problem, and you formulate the questions. So I must admit that he says ki your questions is good, but the manner in which these they have been formulated, this is not good. Because वो जो हमारा judge वाला होता है ना, like, you know, do this thing, that thing. This is, it is not to be done in, you know, when you are sitting as a family court judge. So he formulated all our, you know, sentences or the question in his own, you know, thing. He says it should be like this. So I'll convey this thing to the here,
Yes,
and
it's
we tell them
done.
we should, you know, have a training for it.
Thank you, ma'am.
Even I want that. It should be, even I'll also, if it so happens, I will be also part of it, and we'll all go through the training together.
Thank you, ma'am.
Anything more? No.
May I?
Hanji, please.
Ma'am, I wanted to share one experience.
Hanji,
I mean,
Hanji.
I'm posted at Ludhiana, so we
Okay.
have 4 family courts here,
Okay.
and there is a lot of litigation. We are each are having more than 3,000 files. So we have started 1 or 2 kind of we can say experiments, because wife wants that in petition under section 125, wife wants certainly that maintenance should be decided. Whereas on the other hand, husband does not appear. When he appears, then he tries to delay the matter for filing reply, then filing income affidavit. So what we have started in our courts, that we have started granting ad interim maintenance as a matter of routine. So far as my court is concerned, I'm sure that the other courts had also stated that they will be starting that. So without hearing the opposite parties, I have decided around 400 such cases granting ad interim maintenance pending filing of income affidavit, or in those cases where the husband has been proceeded against ex parte. So without hearing the opposite party, on the basis of income disclosed in the reply, if so, I have started granting ad interim maintenance in all the cases, mentioning that in para number so and so, the husband has stated his income to be 12,000 or 15,000. So considering that the lady is also maintaining 1 child also who is with her, so I have started granting the minimum, I mean 4,000 to 5,000 or 6,000 as the case may be. So to my utter surprise, in all those odd 400 cases, the other party, even if appearing or even if it has appeared later on, they have not protested against that. So in this manner, the relief has been attempted to be given to the destitute wives expeditiously. This is one. Second thing, that in every 125 case, while deciding the case, whether contested ex parte or otherwise, I have started granting 5% annual increase, considering the inflation rate, so that the parties need not to come again. This is another thing. And third thing, ma'am, there was, I mean, an advocate appeared. She was a legal aid counsel. So she asked that maintenance has been granted. Condition of runs are going on. Now the husband is abroad. So what she should do to protect the rights of the lady? So since I also worked in an NRI court at Jalandhar at one point of time, so I was aware of section 10(3)(h) of the Passport Act.
Yeah.
So I asked her that you can move that application, and if you have the particulars of the passport, then passport authority can cancel the passport. So the husband will not be able to travel. So she moved the application, and requisite order was passed, and I hope that the husband will be appearing. So this was part of my experience.
That's nice. Even I used to, you know, do this. I used to pass interim orders, and see, when there is you should, before issuing notices, even in 120, in section 13 or in section 125 also, pass a providing of a litigation orders also. So and so litigation expenses shall be paid by the husband, or this thing. Even when he used to come and appear before they file their, even, they delay filing their affidavit. This is not clear. I need time. So I used to say, okay, then you just give me any this thing, ki how much you can give to your child or the mother, whatever the amount you can, happily consent for it. So they used to say, okay, I, this much I can do it. So before we could decide the application on interim application, so we are used to write, he is directed to file, give this much every month. So in that, what he used to then file his reply or their respective affidavits immediately, The trick used to be, he used to say, like, I can give only 5,000. So I used to say, okay, 7,000. So the 2,000, for 2,000, he used to, file all his, this thing. And again, at the same time, I used to write, if the wife would delay in filing, then she will not have, money for this much money for that month. So she also never wanted to, have this thing like I should lose 5,000 or 7,000 for that month. So you have to, these are the tricks you have to adopt. These are the methods. Hanji, anything?
Any questions? The session has been very interactive. Thank you, Ladyship, for enriching us on the topic of counseling, conciliation, and mediation in resolving family disputes. Thank you so much.
Thank you for making me, part of this session. And I thank you all for attending it. Thanks once again.